Hey everyone, welcome back to the channel. In my earlier video, I dealt with the top 10 most frequently asked questions about power of attorneys in Singapore. And today we'll discuss another 10. Frequently asked question number 1. Can I appoint more than one attorney? Yes, you can appoint more than one attorney. You can choose for them to act jointly, that means they must agree on all decisions, or severally. They can act independently. It is best to empower them to act jointly as well as severally. FAQ number 2. What happens if my appointed attorney dies or becomes incapacitated? Now, if your attorney dies or becomes incapacitated or is unable to act, the power of attorney will no longer be valid unless you have appointed a substitute attorney in the document. It's wise to include provisions for such situations. FAQ number 3. Can a power of attorney be created if the donor is already mentally incapacitated? No. A power of attorney can only be created when the donor has full mental capacity. If the donor is already mentally incapacitated, family members will need to apply to the court for deputyship to manage his affairs. Question 4. Do I need a lawyer to create a power of attorney? Now, while it is not legally required to engage a lawyer to draft a power of attorney, it is highly recommended to ensure that the document is valid and covers all the necessary details. In any event, a power of attorney needs to be signed and stamped with a lawyer's stamp 2 times at the attestation clause, and then it has to be filed with the High Court. FAQ number 5. Can a power of attorney be used overseas? A power of attorney created in Singapore may be used overseas, depending on the laws of the foreign country. But it's important to check with the relevant authorities in that country to ensure that the Singapore power of attorney is recognized over there. For example, if a Greek citizen living in Singapore wishes to execute a power of attorney in Singapore to appoint his brother in Greece to sell his property in Athens, he should check with the Greek embassy or a Greek lawyer whether there is any special required format or whether there are any other formalities to be complied with. Sometimes, certain countries require power of attorneys that are executed overseas to be notarized by a notary public. FAQ 6. How long does it take to execute and file a power of attorney? The process for a lawyer to draft a power of attorney is relatively quick, like 5 minutes if it's a standard template. For customized POAs, it could take up to 30 minutes or more because the clauses have to be customized and specially typed out by the lawyer. Filing the POA with the High Court takes about 10 minutes. The approval time by the court for the power of attorney ranges from 3 to 7 days, but it can be expedited by paying the court an urgent processing fee. Question 7. What are the fees involved in executing a POA? Well, it depends on the law firm. Get quotes from a few law firms, but the fees generally range from $180 to $500. If you need the lawyer to do an out call to a hospital or to Changi Prison or to DLC to witness a donor sign the POA, be prepared to pay an out call fee, which is typically 1 hour of the lawyer's hourly rate. FAQ 8. What is the difference between a will and a power of attorney? Well, a will takes effect after your death, dictating how your estate will be distributed. A power of attorney, on the other hand, allows someone to act on your behalf while you are still alive, particularly if you are overseas or you are bedridden, you cannot leave the house, or you are in prison, or you are unable to manage certain matters. Question number 9. Can I limit the duration of a power of attorney? Yes, you can specify in the power of attorney that it will expire on a particular date or after a specified event, such as the completion of a transaction. This ensures the POA does not extend beyond the necessary time frame. HDB POAs typically last 6 years. You can shorten the HDB POA to less than 6 years, but you cannot extend the HDB POA for longer than 6 years. The duration for a private property and a general power of attorney can be limited to a fixed time period or indefinitely until revoked. FAQ number 10. Do financial institutions in Singapore recognize a POA? Yes. Most financial institutions in Singapore recognize a valid power of attorney. However, banks, brokers, and other financial institutions often have their own internal procedures, so it is always advisable to check with a specific institution to ensure compliance with their requirements. In fact, it is a good idea to ask a lawyer to send a draft of the POA to the bank or the whatever institution to check if the customized clause complies with the bank's internal policies. So there you have it, another 10 most frequently asked questions about power of attorneys in Singapore. Thank you for watching. Don't forget to like, share, and subscribe for more legal insights.